That's all it is all about. Well, that's your joke which taught me about Competition Commission. Competition law is an enforceable ethic to whichever activity it applies, sports, business, agriculture, industry or services. Its potency is contextual. India's colonial political economy suppressed the Indian spirit of enterprise. It also expelled any flourishing Indian manufacture that rivaled the equivalent British manufacturer. Competition with the goods of the colonial power was wiped out as a rule of governance. Imperial law was the instrument for this end. Indian textiles were the classical case of ruin and misery by such politically directed legal behavior. The English Board of Trade would survey potentially rival Indian businesses. The British Commercial Statistical Intelligence provided the database for such economic administration of India. Independence became a necessity. India arrived at its constitutional destiny with this painful lesson on competition as an engine of public interest growth and socio-economic justice. Accordingly, it framed a constitution that nationally captured the essence of the competing human spirit and recognized the laissez-faire abuse. The clear constitutional understanding is that economic policy and management must enable the achievement of the constitutional social order defined in Article 38, which in the particular strives to minimize income and opportunity, inequalities amongst individuals, groups of people having different vocations and residing in different areas. National economic management of the income production process that does not give equality of opportunity defeats the achievement of such a social order, which can be achieved only by economic governance being tied down to subserving the common good and preventing the common detriment. Every government is bound to ensure the two fundamental principles of competition: ownership and control of resources for the common good, and an economic system that does not work to the common detriment. Government businesses is equally bound by these principles. The issue is not of private and or public enterprise. The extension of benefits to all constitutional principles is the duty of the governing political party. This has to be done without infringing fundamental and constitutional limits. That is why the Competition Act 2002 defines enterprise in Section 2H to mean a person or the government engaged in any activity in the whole range of investment and production, up to the delivery of goods and services. The only exception is the activity of the government relating to sovereign functions, which for the central government include atomic energy, currency, defense, and space. The twin goals with the fundamental rights of fair, just, and reasonable state conduct in management of political economy constitute the boundaries of a host of laws, including the control of monopolies and restrictive business practices and agreements. As with many things human, which go in pairs, the economic development in India gave rise to an economic greed, working to the detriment of development itself. India brought in the controlling legislation of the Monopolies and Restrictive Trade Practices Act 1969. Paradigm could only be the thought through control and prohibition. When by 1990 the administered economy was found to be working to the common detriment, the political economy of the globalized regulated market, liberalization started replacing the administered economy. The feeble markets of the 1950s had by the 1990 become major income and wealth production markets. With the serious problems of non-transparent political management of resources, that tended to seriously retard the achievement of the social order mandated by the Constitution. Agreements, combinations, and dominance in the competition to earn more from new and larger business became necessary. The nature of this competition determined job growth through allocation of resources. It affected prices of goods and services and therefore consumer demand. There was a necessity to keep a check on the competition for more to enable the fulfillment of the twin constitutional goals of subserving the common good and preventing common detriment. The answer was to replace the controls of Monopolies and Restrictive Trade Practices Act 1969 by the nuanced regulation of the Competition Act 2002 to encourage competition and rein in its abuse, not on any dogmatic basis or the per se rule, but on the reasoned basis of the rule of reason. This kind of relationship of fairness between the manufacturer-supplier on the one hand and the consumer on the other is possible only if the stream of supply and demand remains unpolluted. Greed pollutes the stream. There is as yet no vaccine against greed. Hence, the Competition Commission is a necessity to prevent, control, and abate such pollution. The doctrine of the level playing field is the constitutional answer to the displacement of the competition to the common detriment. A Competition Commission becomes a necessity to enforce this doctrine. The Competition Act does this by imposing a national monitoring function on the Commission to ensure fair competition. An armada of powers concerning agreements and combinations, having an appreciable adverse effect on competition, as also abuse of dominant position, a range of remedies of financial deterrence, including the power to issue interim orders, combined with the principles of natural justice. In the Steel Authority of India case, the Supreme Court in 2010 pointed out that under the scheme of the Act, the Commission is vested with inquisitorial, investigative, regulatory, adjudicatory, and to a limited extent, advisory jurisdiction. It further stated that vast powers had been given to the Commission